why this says waiver consent to stipulation of testimony and stipulations. You know what that means? That means that everything is in this document. You're stipulating that it is true and correct. And this is what it says. Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lutenberger, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yep.
That's
Yes.
either yes or no.
Yes.
All right. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
The proceeding on the proceedings, it's all bodily injury.
Counsel, have you received all
No
discovery?
objections, Your
Did you review
Did
it
you
with your
review the
client?
court
Admonishments with
Court
your
will find
attorney?
that the
Did you
state is in
understand it and
compliance
sign
with
it in all the
discovery?
appropriate places? Mr. Lutenberger, did you
Thank
review the
you.
application for deferred adjudication
No.
with
Did you
your
review
attorney?
this
Did you
document?
understand it and
Did you
sign it?
understand it?
Yep. Yep.
Did you
That's
sign it
yes
in
or
all the
no?
appropriate places? All right.
Yes.
Did you
No.
review the true
state
bill of
is proceeding
indictment
on
with
the
your
lesser
attorney? Did you
included
understand
offense of
it?
assault,
Bodily injury.
Counsel, do you
As a
waive the
class
reading
A
of the
misdemeanor,
indictment?
the range
We do,
of
Your Honor.
punishment
State,
is
are you
anywhere
proceeding
from a
on the indictment as
$4,000
presented?
fine and up to 1 year in the Bexar County jail. Did you understand?
Proceeding on the proceedings.
If you have a plea with the state, the court does not have to follow
Any
your plea.
objections?
No
If for
objections,
any
Your Honor.
reason the court
Did you
does
review
not
the
follow
court
your plea and
admonishments
gives you
with your
more
attorney?
than
Did you
bargained for,
understand
the
it
fact
and
that
sign
you
it in
entered a
all
plea
the
will not be
appropriate
used
places?
against you and you will be allowed to
Thank
withdraw your
you.
plea. Did you understand?
No.
Did you
Yeah.
review this
You
document?
have a right to jury
Did you
trial, a right
understand
for
it?
you or your attorney
Did you
to
sign it in all
cross-examine
the
and
appropriate
confront any
places?
witnesses the
No.
state will call
The
in the right
state
to
is
remain
proceeding on the
silent.
lesser
By
included
entering this
offense
plea,
of
you're giving
assault,
up those
bodily
rights. Did you
injury.
intend to
As
give
a
up those
class A
rights and enter
misdemeanor, the
into a
range
plea
of
in this
punishment
case?
is anywhere from a $4,000 fine
Did you understand
and up
if
to
the
1
court
year
were
in
to
the Bexar
grant your
County jail.
application for
Did you
deferred
understand?
adjudication, if for any reason
Yes.
your deferred
If you have a
adjudication
plea
were
with the
revoked,
state,
the court does not have to follow your plea and sentence you
If
up
for
to
any
1 year
reason
in
the
the Bexar
court does
County
not
jail
follow
and
your
up to
plea
a
and gives you more
$4,000
than you
fine. Did you
bargained for, the
understand?
fact that you
Yes.
entered a plea will not be used against
Counsel,
you
has
and
your
you will
client
be
been able to
allowed to
provide you
withdraw
with any
your plea.
defenses?
Did you understand?
He has, Your Honor.
Do you have a
believe
right
he
to
has a
jury
rational
trial as
right
well as
for
a
you or your
factual
attorney to
understanding of the charges
cross-examine and
against
confront
him?
any
I do, Your
witnesses the
Do you
state
believe
will
his
call in
current
the
right
right
to remain
was legally
silent?
sane at
By
the time
entering
of
this plea, you're
offense?
giving
do,
up
Your
those
Honor.
rights.
Mr.
Did you
Lutenberger,
intend to
has
give up
anyone
those
threatened you,
rights and enter
coerced you, or
into a
placed
plea
you
in
in
this
fear to get
case?
you to enter this plea?
No.
Anyone
Did you
promise you
understand if the
anything
court were
other
to
than the
grant your
plea?
application for
No.
deferred
Are you
adjudication, if
satisfied
for
with the
any
way you've
reason
been
your deferred
represented?
adjudication were revoked, the court could find you guilty and
If
sentence
you're
you up
not
to
a
1
U.S.
year in the
citizen,
Bexar
by
County
entering
jail
this
and up
plea,
to a
you will be
$4,000
deported
fine.
and
Did you
denied
understand?
naturalization and denied re-entry into
Counsel,
the
has your
United
client been able to
States. Did you
provide you with any
understand?
defenses?
Yes. He
Court will
has, Your
find
Honor.
that defendant
believe
has
he has a
knowingly and
rational as well
voluntarily
as a
waived his
factual
right to
understanding
understanding of
trial?
the charges
Did you
against him?
review
I do,
the
Your
plea
Honor.
bargain
Do you
page
believe
with
he's
your
currently
attorney? Did
competent
you
and was
understand
legally
it?
sane at the
Yes.
time of
According to the
offense?
plea,
I
the
do, Your
state
Honor.
is
Mr.
proceeding on the
Lutenberger,
lesser
has anyone
included
threatened
offense
you,
of
coerced
assault,
you,
bodily
placed you in
injury.
fear to get you to
There's
enter
a
this plea?
$500 fine
No.
and the state
Anyone
recommends
promised you
deferred
anything other
adjudication.
than the
Did
plea?
you understand that to be the
No.
plea? Are you
Yes.
satisfied with the way you've been
Yes, Your Honor.
represented?
State, it is, Your Honor.
Did you review the waiver of appeal paragraph
Yes.
with your attorney?
If
Did
you're
you
not a
understand
U.S.
it and
citizen,
sign
by
it in
entering
both
this plea, you will be
places?
deported and
By
denied
signing that, you're waiving your
naturalization
right
and
to
denied
appeal. The only
re-entry into
items
the
that
United
can be
States.
appealed
Did you
are
understand?
written pretrial
Yes.
motions that have been
Court will
filed,
find that
heard, and
defendant
ruled
has
upon by
knowingly
the
and
court. Did you
voluntarily waived
understand?
his right to
Yeah.
jury trial.
That's
Did
a
you
yes or
review
no.
the
Yes.
plea bargain page
Counsel,
with your
have there been
attorney?
any
Did you
such
understand it?
motions?
Yes. No, Your Honor.
According to the plea,
Outside
the
the
state is
agreement, the
proceeding
state
on the
is
lesser
requesting
included
that your
offense
community
of assault,
supervision
bodily
be for a
injury
term of 2 years.
There's a $500
There'll be a
fine
TAP
and the state
evaluation.
recommends deferred
200 hours
adjudication.
community
Did you
service
understand that to be the
restitution.
plea?
Yes.
No
Attack
contest
with Mario
Yes, Your Honor.
Montemayor and the
Did you review the
hostility
waiver of appeal
management
paragraph
course.
with your
Did you
attorney?
understand
Did you
those were
understand it and
recommendations
sign
from
it
the
in
state
both
and the court does not have to
places?
follow those
Yes.
By
recommendations?
signing that, you're
Yes,
waiving
fine.
your right to
Then to the
appeal.
lesser
The only
included
items that
offense, how
can
do
be
you plead?
appealed
Guilty, not
are
guilty,
written
or no
pretrial
contest?
motions that have been
No contest.
filed, heard, and
State
ruled
any
upon by the
evidence.
court. Did you understand?
Yes.
That's
No
either yes
objection,
or
Your
no.
Honor.
All right, and state, have you had a
Counsel,
chance to
have
speak
there
with the
been any
complainant?
such motions?
All right, thank you.
No,
You may
Your
be
Honor.
excused.
Outside
Did you
the
review the
agreement, the
waiver and
state is
stipulations
requesting that
with
your
your attorney?
community
Did you
supervision
understand
be
it
for a
and
term
sign
of
it
2
in all the
years.
appropriate
There'll be a
places?
TAP evaluation.
Again, did
200
you
hours
understand you have a
community
right to
service
jury
restitution.
trial, a right for
No
you or your
contact with
attorney to
Mario
cross-examine
Montemayor
and confront
and the
any
hostility
witnesses the
management
state would
course.
call in the
Did you
right to remain
understand those were
silent?
recommendations recommendations from
Yes.
the state, and the
Did you
court does
understand
not
that
have to
today
follow
the state
those
would be presenting
recommendations?
evidence in the
Yes,
form of
Then
witnesses'
to the
statements,
lesson
including
police
offense,
reports,
how do
but
you
most
plead guilty, not
importantly,
guilty, or no
no
contest?
live
No
testimony. Did you
State any
understand?
evidence.
yes,
Court will find that defendant has knowingly and
No objection,
voluntarily
Your Honor.
waived
All right,
and
and state,
consented
have you had a chance to
stipulation
speak
of
with the
testimony
complainant?
and
All right,
stipulations.
thank you. You may be
Court will
excused.
accept into
Did you
evidence
review the
states
waiver and
exhibits 1 and
stipulations with
attachments
your
and
attorney?
reviewed the
Did you
same.
understand it
States
and cited
exhibits
in
1
all
and
the appropriate
attachments. The court will
places?
find there is sufficient evidence
Again,
to
did
find
you
you guilty.
understand you have a right
Court
to
will
jury
defer
trial,
finding
right
of
for
guilt as
you
you
or your
applied for
attorney to
deferred
cross-examine and
adjudication.
confront
Are you proceeding with
any
sentencing?
witnesses the state
We
will
are,
call
Your
in the right to
Anything
remain
you wish to say
silent.
on behalf of your client?
yes.
Just that
Did you
we- which
understand
day
that
you follow
today
the
the state will
agreement,
be
Your Honor.
presenting
right,
evidence
what
in
were
the
your
form of
issues that
witnesses'
day?
statements and police reports,
Well,
but
my
most
issues that day?
importantly,
Yes.
there'll be no
Well,
live
I couldn't
testimony.
believe
Did you
it was
understand?
happening, because all I wanted to do was
Court will
go
find that
vote.
defendant has knowingly and
No, the
voluntarily
problem
waived
is,
and
was
consented
not
to
you going to
stipulation of
vote.
testimony and
And I will tell you,
stipulations.
I teach
Court will
campaign and
accept into
election law.
evidence states exhibits one and
And when
attachments and
people
review the
at a
same.
location
States
tell
exhibits have
you
attachments, the
that
court
you're
will
not
find there's
allowed to
sufficient
wear
evidence to find you
certain
guilty.
items when you
Court
go
will defer
into the
finding
voting
of
booth.
guilt
You're
as
not
you've
allowed to
applied
do
for
that.
deferred
When they tell
adjudication.
you you're not
Are you
allowed to
proceeding
wear
with
certain
sentencing?
items
Oh,
when
we
you're
are,
entering doors, you're
Anything
not
you wish
allowed
to
to
say
do
on
that.
behalf of your
They
client?
told
Just that we-
people
which
to
day you
post
follow
it
the agreement,
anywhere,
Your Honor.
and the people that were
right,
watching
what were
that
your
didn't
issues
know
that day?
themselves.
No, that's the law.
Well, my issues
I'm telling you,
that
that's
day?
the
I'll
law.
tell you, I didn't know, and other people didn't know it was happening, because all I wanted to do was go vote. So I'm explaining my situation.
No, the problem is, was not you going to vote. And I will
let me
tell
just
you, I
what it
teach
says in
campaign
here,
and
in the
election
police
law.
report, because maybe you didn't read
And
it.
when people at
It
a
says
location tell
You were
you
walking
that you're
in,
not allowed to
and the person,
wear
they
certain
have
items
judges
when you
who are
go
there for
into the
voting, and
voting
they have
booth, you're
people
not
who are
allowed to do
working
that.
there.
When they tell you you're not
who
allowed to
work
wear
there.
certain
It's
items
yes or
when
no.
you're
It's not,
entering doors, you're not allowed to do that.
They were
They told
working
them
there,
they
and they
posted
told you you
anywhere,
needed
and
to
the people
remove
that
your
were
hat
working there
because it
didn't
was
know
not
themselves.
allowed
They would've
inside
told me
the
that.
voting
I'm telling you, that's the
I'll
law.
tell you, I didn't know,
And
and
that's the
other
law.
people
And
didn't
that's
know.
always, but here's the thing.
Well,
that's the law. It's always been the law. For example, I can't walk around with a
let me just tell you
T-shirt
what it
with
says
my
in here,
name
in
on
the
it
police
saying
report,
vote
'cause
for
maybe
me
you
and
didn't
go in
read
the
it.
voting booth. It's not
It
allowed.
says
Once you
you
get
were
to a certain
walking
point,
in,
and it's that
and the
100-yard
person,
line that
they have judges who are there
when you
for
cross
voting,
into
and they
that
have
area,
people who are
you're not
working
allowed
there
to be in line
who
with
work there.
T-shirts
It's
about
yes
who
or
you
no. It's not,
support. You're not
uh-huh.
allowed to do that.
They were working
That's the
there,
law.
and they told
And
you
then
you needed to
when
remove
people
your
tell you
hat
that,
because it was
you can't
not
start hitting
allowed
somebody
inside. And
the
it says on
voting
here
area.
that your
And
wife
that's the
even
law.
tried
And
to
that's
stop
always,
you.
but here's the thing. That's the law.
Ma'am,
It's
that's
always
all
been the law.
incorrect. Do you
For
want me to
example,
explain?
I
Can
can't walk
explain?
around with
Sure,
a
and if you want a
T-shirt
jury
with
trial,
my
I'll give
name
you
on it
one.
saying vote for me and go in the voting booth.
Explain
It's
it
not
because
allowed. Once you
you're-
get to a certain
it's
point, and it's
incorrect
that
what they're saying. I was in
100-yard
line for
line that they
45
have.
minutes
When you
before
cross
I
into
actually
that
got to
area,
vote.
you're not
They
allowed
asked
to
me
be in
remove my hat
line
then,
with
after I was
T-shirts
standing there
about
for
who you
45 minutes.
support.
So I
You're not
removed
allowed
it.
to
I
do
put it in
that.
my lower back.
That's the law.
I went through the whole
And then
situation.
when people
When I
tell you
went out
that,
the other
you
side,
can't start
this
hitting
person
somebody.
And it
had
says
already
on
harassed
here
me in two
that
other
your wife
previous
even
times
tried
that I
to
went
stop
go
you.
vote in a different location.
Mhm.
Was again there. I walked away from him twice. Two other times. When he
Sure, and if you
verbally
want a jury
harassed me.
trial, I'll give you
Okay,
one.
this is the third time. And the third time, I walked away from him again twice. It's incorrect what they're saying. I was in line for 45 minutes. And before I actually got to vote, they
All right,
asked
so
me
let
to
me-
remove my hat then. after
Let
I
me
was
tell you
standing
what
there
it
for
says in
45
here.
minutes. So
And I go
removed it,
by
put it in my lower
this
back.
document.
I went through the whole voting situation.
It says that the
When I went out the other
complainant
side,
went on
this
by
person
explaining
that
that as
had
part
already
of his
harassed me
duties, he is
in two
supposed
other
to advise
previous
voters
times that I
that
went to
they
go
are
vote
not
in a
permitted
different
to wear
location.
or display
Was
candidates
again
on their
there. I
person
walked away from
while
him
they
twice,
are
two other
on the
times,
polling
when he was
premises.
verbally harassing me.
It
Okay, this
says
is the
he
third time. And
observed
this
an
third time,
older
I walked
adult
away
male
from him
inside
again
the polling
twice.
premises,
He would
and
not
you
let me
had
walk out of that place
displayed
without harassing me
campaign
and getting
material, which
physical
was
with
your
me.
hat. All right, so
That's what
he
my wife was
observed the
trying to-
violation.
Let me tell you what it says
He
in here.
contacted the male
And I
and
go by
advised him that he
this
would need to
document.
refrain from wearing the hat while on
It
the
says
premises.
that the complainant went on by explaining
complainant
that as part of
explained
his
that the
duties,
male
he is
complied
supposed
with
to
his
advise
instructions
voters
while
that
he was
they are
voting,
not
but then
permitted
put the
to
hat
wear or
back
display
on
candidates on their
as he
person
was making his
while
way to
they are on
exit
the
the
polling
premises.
At the time, the male was still
It
inside the
says
building
he observed
and
an
clearly
older
well
adult
within the
male
premises.
inside the polling
Due
premises,
to still being well
and you
within the
had
premises,
displayed
he
campaign
approached you
material,
again and
which was your
advised you to
hat.
remove the hat while he was
He
on the
observed the
premises.
violation. He
The
contacted
male
the male
that
and
you
advised
explained
him that he would
on
need
his
to
way out and
refrain from
refuse
wearing
to
the hat
comply.
while on the premises. The complainant explained that the male complied with his instructions
And it
while he was
says,
voting, but then put the hat back on
He
as he
began to
was
follow
making
you
his way
and
to
told you again to
exit the
remove your
premises.
hat.
At the time, the male was
And
still
as you were
inside the
about to
building,
exit,
and you
clearly
struck him
well
on
within
the
the
chest and
premises.
facial area
Due due to
area
still being
several
well
times
within the
with
premises,
your fist, causing him
approached
pain
you again
and
and
advised you to remove the hat while he was on the
And
premises.
then it says another witness,
the
in your
male that
wife,
you explained that he was on
began
his way
telling
out
you to
and
stop.
refused to comply. And then that's when you left. I don't know
And it
why when people go to
says-
places,
how hard it is to follow instructions.
He began to
When they
follow
say
you
you can't
and
do
told
something,
you
you
again
can't
to
do
remove
it.
your
And if
hat.
you want to complain about it, complain to your
And as you
legislature.
were about to
If
exit,
you want to wear
struck him
campaign
on the
materials
chest in
inside a
facial
location while you're voting,
area several
if you want to
times
wear it
with
within the
your
100
fist,
lines,
causing him pain
because they have
and
those lines
discomfort.
marked with a white, sometimes yellow line.
And then
If you
it
want to do
says
that, then you
another
need to write your
witness and
legislator
your
and say, look,
wife
you need to change these rules because
began
I want to
telling you
wear
to stop.
my campaign gear
And
inside
then
the
that's
area
when
while
you
I'm
left.
voting. But for now, you're not allowed to do that. And you need to
I don't know
follow the
why
rules.
when people go
How
to
old are you?
places,
How hard it is to follow
all right,
instructions.
you're 64.
When they say you
and you're
can't
up here
do something, you
fighting
can't do it. And
at
if you want to
a-
complain
and I
about
don't
it,
even call
complain
it
to your
fighting because it
legislature.
doesn't say that
If
he
you want
ever
to wear
even hit you back.
campaign
Yeah,
materials
perfect.
And
inside a
so
location while
you're
you're
up
voting,
here
if
fighting
you
with
want to
somebody
wear it
who's
within
just
the
trying
100
to do their
lines,
job, help people
because they
come
have
in and
those
vote and
lines
go on your
marked
merry
with the
way.
white,
And they're not
sometimes
even
yellow
paid
line.
enough money for
If you want
somebody
to do
to
that,
be
then you
hitting
need
on
to
them.
write your legislator and say,
So
look, you need to
it
change
appears
these
to me you
rules
do
because
have
I want to
anger
wear
issues.
my
I don't have
campaign
any. Like I said, I
gear
walked away
inside
twice
the area
in the
while I'm
situation I
voting.
walked away
But
from.
for now,
Didn't say anything,
you're not
never
allowed to
hit-
do that.
followed
And
me
you need
all
to
the way,
follow
and
the
he
rules.
screamed in
How
my
old are
ear.
you?
I have hearing difficulties for one time in the
All right,
military.
you're
I
64
didn't hear what he
and
was
you're up here
saying. I was
fighting
walking out.
at
He was-
and I don't
Quite
even call
right.
it
Did he
fighting
not
because
tell
it
you to
doesn't
remove
say
your
that he ever even
campaign
hit you
gear?
back.
Yeah, of course.
And that you
And
were not
so
allowed
That
you're
in the
up
area
here
That was
fighting
after
with
the fact when
somebody
I heard
who's
him
just
on
trying
out.
to
I
do
was
their
in the
job, help
library
people come
section.
in and vote and go on your
Already.
merry way.
Let
And
me
they're
just
not
tell
even
you,
paid enough money for
within
somebody
that
to
100
be hitting
line,
on them. You are not allowed to
So
wear
it appears to me you do
campaign
have
gear.
anger issues.
Now,
No, I
if
don't
you're
have
saying
any.
what's
Like I
being
said, I
said
walked
is
away
untrue, then
twice
you need to
in
set this for a
situation I
jury
walked
trial
away twice.
because I go
Didn't say anything, and
specifically
he
by what's
followed me all the
in
way,
the
and he
police
screamed in
reports.
my ear.
And there's
I
a
have hearing
reason why
difficulties
this
from the time
says
in the military.
Waiver
I didn't hear
consent
what
to
he was
stipulation
saying.
of
I was
testimony and
walking out.
stipulations. You
He
know what
was
that means?
By
That
the
means
way,
that
did he not
everything
tell
is
you
in
to
this
remove your
document.
campaign
You're stipulating
gear
that it is
No.
true
and that you were not
correct.
allowed
That was-
in the
And
area?
this
That
is
was
what it
after the fact
says.
when I had already gone out. I was in the
I,
library
Jesse
section.
Lutenberger, do
Already.
hereby judicially
just tell you,
confess and admit
Within
that
that
I
100 line,
intentionally and
you are
knowingly
not
in Bexar
allowed
County,
to wear
Texas, on or about
campaign gear.
the 24th
Now, if you're saying
October
what's being said is
2024,
untrue, then you need to set this for a jury
did
trial
intentionally
because I
and
go
knowing cause
specifically
injury
by
to the
what's
complainant,
in the police reports.
by striking
And
the
there's a
complainant
reason
with the
why
hand
this
of the
says
defendant and by pushing the
waiver
complainant with the
consent to
hand of the
stipulation
defendant.
of
Testimony and
That's- you
stipulations. You know what that
stipulated to that
means?
and said it's
That
true.
means that everything is in this
Anything about him
document.
punching
You're
at me
stipulating that it
What
is
I'm
true
telling you
and
is
correct.
you're staying,
And
this is
true.
what it
I
says.
get
You've
it.
stipulated to this.
Now, if
I,
you're saying
Jesse
he punched you first,
Lutenberger, do
then maybe
hereby
you want a jury
judicially
trial and you want to
confess
say it's
and admit
self-defense.
that
It's
I
on video. The only
intentionally
reason
and
why I'm
knowingly
accepting
in
that,
Bexar
I don't
County,
have money to
Texas,
continue.
on or about
Or
the
of course I would
24th
defend myself.
of October
Does he not want to
2024,
No,
did
We're
intentionally
accepting
and knowing
the-
cause
you know,
injury
Is
to
your
the
wife, is somebody
complainant,
here?
my wife is here.
by
she said,
striking
no,
the
you don't want a
complainant with the
jury
hand
trial.
of the defendant and by pushing the complainant with the hand of the
All
defendant.
right. That's, you stipulated
Your
to that
Honor,
and
if
said
I
it's
may,
true.
I believe that
Say anything about him punching at
point
me
being
first.
there's,
What I'm telling
as
you
you
is,
stated,
you're
that's completely
staying,
clear. The
this
law
is
is the
true.
law.
I
I
get
think
it.
that there
stipulated
was
to
a
this. Now, if
fundamental,
you're saying he punched
fundamental
you first,
miscommunication
then maybe you want
and
a jury trial and you
understanding
want to say
as
it's
far as how it
self-defense.
was
It's on
proffered
video.
to him
The
at
only
that
reason why I'm
time.
accepting that,
I
because I don't
think
have money to
that
continue.
realistically, the
Well,
way
of
people
course I would
speak,
defend myself.
someone told him,
All right,
take
does he
off the
want a jury
hat while
trial?
you're voting. I think in
No.
his head,
We're
that's
accepting
what
it.
he believed.
No.
Hey,
Is
take
your
the hat
wife-
off.
is somebody
I'm
here?
walking out
My
the
wife is
door.
here.
Oh,
I'm
she said, no, you
basically
don't
at
want
the
a jury
double
trial.
doors.
Okay,
I
no.
can put the hat back on. Understanding
All right.
clearly that is still in Your Honor, violation if of I the may, law. I believe that I want to make clear, point being, it's not like a statute that was completely clear. The law out and read to him. I think that there was a fundamental, 100 fundamental miscommunication and understanding where, as far as his mind was coming at, to him at finished voting. I think that waited 45 minutes, people speak, and he was leaving. Someone told him, take off the hat while you're voting. I think in his head, just to give some context, hey, it's not take the hat off, obviously, I'm walking out the door, the law itself, or basically at the double doors, but I can put the hat
Well, I
back
mean,
on.
my viewpoint is
Understanding
the
clearly
stipulations that I
is
received.
still in violation of the law. But I want to make clear,
All
it's not
right.
like the
There's going to be a
statute book was not
$500 fine,
pulled out and read to him at this
2
time
years
to
deferred
understand the 100
adjudication,
feet. Again, it's not an excuse.
200
I think
hours of community
where
service
his mind was coming
restitution,
at, he had finished
proof of
voting,
employment within 30
waited the 45
days,
minutes,
no
and he
employment
was
as a
leaving,
home health
and
care
then
provider.
he had an individual come up and
minors.
approach him. Just to give some context,
There's gonna be
it's
the
not changed,
hostility,
obviously, the law itself or your
management
viewpoint of this,
course.
but I want to.
Well, I mean, my viewpoint is the stipulations that I've read by
Understood.
Zoom or in person. Regular
All right.
random UAs. There's going to be a $500 fine. Field visits one time per 2 month years for deferred adjudication. And there's to be
200
no
hours of
community service restitution. Proof of employment within 30 days. no employment as a home health care provider or with minors.
Probation, is there anything else?
There's going to be the hostility
Judge.
Is there
management
anything else you need
course,
from the court to be successful?
No, I think
regular
I'd say
reporting by
that our
Zoom
citizens
or in person,
might self-defense.
regular random
Because nobody wants
UAs,
to be harassed or bullied in front of
field
their
visits one time per month
their
for 6 months.
significant other.
Yeah.
Because-
And there's to be
You know
no
what? I understand
contact
here's the thing. I understand what you're saying. And I understand sometimes
Mario
that tempers run high,
Montemor.
right? And sometimes when we don't know the law,
Probation,
and if
is there
somebody
anything
else just tells you, you can't do that, sometimes people want to know why I can't do that.
Is there
And
anything
they
else
want
you need
to
from the
explain
court to
it.
be
Sometimes
successful?
people will explain it, sometimes
No,
they
I
will
would
not.
Say that
For example, I
our
try to explain
citizens
everything
might
so people will know
self-defense.
why things are
Because
happening.
nobody wants to
So
be
now you
harassed or
know,
bullied
and I'm
in
telling
front of
you. Yeah, yeah.
their
So here's the thing.
significant
This is what I'm telling you.
because-
When you see,
you know what?
if
I
you go
understand
vote
what-
again,
here's the thing.
when you see
I
that
understand what you're
line,
saying.
and I understand
You are not to cross that line with
sometimes
any campaign
that tempers
materials.
run high, right?
And that's why when you
And
see
sometimes
candidates
when
who
we
are
don't
out
know
there
the law,
talking to people,
and if somebody
they're not allowed to
just
go past
tells
that
you,
line.
you
You
know
can't
why?
do that because you are not
Sometimes
allowed
people
to
want to know why I
campaign
can't
past
do
that
that.
line.
And they want
And
you to explain
wearing,
it. Sometimes people will explain it. Sometimes they will not.
T-shirts
For
or any
example,
type
I
of
try to
hats or
explain
anything
everything so
for
people
whatever
will know
candidate you support,
why things are
whether
happening.
you say anything
So
or
now
not,
you know,
that's
and I'm
considered
telling you.
campaigning. And
Yeah,
legally,
yeah.
you're not allowed
So
to do
here's the
that.
thing. This is
And
what
if
I'm
people
telling
want
you.
to change the law
When
where
you
they can
see-
wear their
if you go
campaign
vote
shirts or
again,
whatever
when you
beyond
see
that
that
line,
line, you have to do that with
you
your
are not to
legislators.
cross that line with
My
any
job
campaign
is just to follow
materials.
the law. You understand?
And that's why when you see candidates who are
Yeah.
out there talking to
You know,
people,
this happened in
they're not
Georgia,
allowed to
it
go
happened
past
in
that line. You know why?
South Carolina,
Because you are
and
not allowed to
the people
campaign
still got
past
to
that
go in
line.
when I'm
And
paid.
wearing
Well,
this-
Different place, right?
this
T-shirts
Texas,
Yeah.
or any
All
type
right,
of
did
hats
you
or
review the
anything
document entitled
for whatever
trial court
candidate you
certification of
support,
defendant's rights
whether
to
you
appeal
say
with your
anything or
attorney?
not,
Did you
that's
understand
considered
it and
campaigning.
And
Yeah.
legally,
All right,
you're not
because,
allowed to do that.
This
And
is
if
plea
people want to
bargaining
change
agreement
the
because
law
I
where they can
followed
wear
your
their
plea bargaining
campaign
agreement
shirts or
because you
whatever
waived your
beyond
right
that
to
line,
appeal,
you have to do
you
that
do
with
not
your
have the court's
legislators.
permission to
My job
appeal.
is
Do you
just to
understand?
follow the law. You understand?
Yes, ma'am.
All right.
Yes.
Ms.
You
Abrams
know,
will
this
speak
happened
to
in
you.
Court
Georgia,
is
and it
calling
happened in
2022
Carolina,
CR
same thing. The people still got to go
2010
in
State
when
of
I'm
Texas
paid.
versus Houston.
Well,
Dwight
this
Different
Stewart.
place, right?
Could I have
This
parties
Texas-
announced for the record for the state?
All right. Did you review the document entitled trial court certification of defendant's rights to
And are
appeal with
you
your
Houston
attorney?
Stewart?
Did you understand it and sign it?
Showing
Yeah.
you what's entitled
All right,
motion to enter
because,
adjudication of
this
guilt
is
and
plea
revoke
bargaining agreement
community
because I
supervision.
followed your
And
plea
First
bargaining
Amendment
agreement
motion to
because you
enter
waived your
adjudication
right
of
to
guilt and
appeal.
revoke community
You do not have
supervision.
the court's
Did you review
permission
that with
to
your attorney?
appeal.
Did you understand it? Are you the
Yes, ma'am.
same Houston
All right.
Dwight Stewart who
Ms.
was
Abrams
placed on
will
deferred
speak to you.
adjudication in 2022 CR 2010 for the offense of possession of a controlled substance penalty group 1 less than 1 gram on April 13, 2022 for a period of 2 years. Is that you? State.
Violating condition number
And
2.
are you
on or
Houston
about the
Stewart?
26th day of January 2024. in
Showing you
Bexar
what's
County,
entitled
Texas.
motion to enter
defendant,
adjudication of
Houston
guilt and
Dwight
revoke
Stewart,
community
defendant there
supervision.
consumed
And First
alcoholic
Amendment motion
beverages
to
in
enter
violation of
adjudication of
condition
guilt and
number
revoke community
How do you plead
supervision.
to that? True
Did
or
you
not
review
true?
that with your attorney? Did you understand it?
True.
Are you the
Your Honor,
same
favor of all
Houston
the
Dwight
violations.
Stewart who
Any
was placed on
objection?
deferred
No objection, Your Honor.
adjudication in 2022 CR 2010 for the
All right, did
offense
you
of
understand
possession
by
of a
pleading
controlled
true to
substance penalty
violation of
group
condition
1
number 2,
less
the court
than 1
can find
gram
it
on
true,
April
grant the
13,
motion,
2022
find you guilty,
for a
send it
period
to
of
up to
2
2
years
years.
in
Is
the
that you?
state jail facility and up
State?
to $10,000
Violating
fine?
condition number 2 on or
Knowing
about
that,
the
do you still
26th
wish
day
to
of
plead true to
January
violation of
2024
condition
in
number
Bexar County,
2?
Texas. The defendant, Houston Dwight Stewart,
Court will
defendant
find
there
violation of
consumed
condition number 2
alcoholic
true.
beverages
Is there
in
proposed
violation of
agreement?
condition number
There,
2.
Your Honor.
I
How do you
did
plead
sign
to
that
that, true or
amended,
not true?
NTR today, so I think the defense needs to waive the
Your Honor,
10
state
days.
waives all the
Ah,
violations.
Okay, I
Any
didn't see that
objection?
date.
No objection.
All
Your
right,
Honor.
do you waive
I do.
notice?
Yes.
All right, yes.
So the recommendation.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of
All right,
condition
is that
number
your
2? Proposed agreement?
It is, Your Honor.
Are you asking the court to follow that agreement? Court will find violation of
Are you
condition
waiving your
number
right
2
to
true?
appeal?
Is there a proposed agreement?
There's, Your Honor, I did sign that amended.
All right, so how did, raise your right
NTR
hand for me,
today,
please.
so,
Do you
I
solemnly
think the
swear or
defense
affirm the
needs to waive
testimony you
the
give
10
will be the
days.
truth and nothing but the truth, so help
Okay,
you
I
God?
didn't see that date.
All right, All right,
can
do you
lower your
waive?
hands.
State your name for the record.
Yes.
All right, yes. All right, how did you get
So,
here
the
today?
recommendation for the agreement is TAP evaluation, intensive.
So why are you
outpatient
using
treatment,
drugs on this probation?
90 sober support meetings in 90 days, and either monthly UAs or the drug patch.
It's kind positive
All right,
testing.
is that your proposed
I
agreement?
was
It
just
is,
a
Your
little
Honor.
stressed
Are
out.
you asking the court to follow
So
that
I did
agreement?
yes, ma'am.
Are you waiving your right
So
to what about the drinking?
I really don't have.
All right, so raise your right hand for
strong
me,
reasoning
please.
for the
Do you
drinking. I
solemnly
just-
swear or affirm the testimony
I
you
was
give will be the
just
truth
chilling,
and nothing but
relaxing,
the truth, so help you God?
Well,
All right, you know you're not supposed to drink alcohol on probation. All right, how did you get here today?
I
Probation.
got dropped off.
All right,
Um,
so why are
just
you
so close
using
to
drugs
finishing,
on
I
this
just, I
probation?
wasn't thinking. Which, you know what I'm saying?
Oh, celebrating.
Yeah.
That's what it was. And now you're not close to
It's-
finishing
It's kind of,
because I'm going to extend you.
positive testing. I was just a little stressed out. So I did.
And you know
take
why I'm
it.
extending you? That's part of punishment. So what about the drinking? It's no rehabilitation associated
I
with that.
really don't
That's
have
part of
a
punishment.
Strong reasoning
Because
for the drinking. I just,
when
I
you
was just
finally
chilling,
finish
relaxing,
something, are
I
you
had
close to
beer.
finishing stuff?
Well, no, you know
something
you're not supposed to
take
drink
stock
alcohol
and
on
say,
probation.
okay,
Those-
how did I
that's
end
part
up
of the
here?
punishment of
And
probation.
you know what? I'm going to make sure that I don't end up back here.
Just so close to finishing.
And
I
instead,
just,
you
I
didn't
don't know,
take
wasn't
stock.
thinking.
Instead, it's like,
You know what I'm
oh,
saying?
celebrating. I'm free. I can do whatever I
Yeah.
want to. That's what it
And you
was.
can't.
And now you're not close to
All right,
finishing.
this is what the court will
Because I'm going to
do.
extend you. Court is going to deny the motion. And you know why I'm extending you? That's part of punishment. It's no rehabilitation associated
Alternate
with that. That's part of
conditions.
punishment. Because when you finally finish something or you're close to
include the
finishing
following.
something, you're
There's
supposed
to
to
be
take
no
stock and
driving
say, okay, how did I end
until
up here?
further notice.
And you know what? I'm going to make sure that I
Extend
don't end up back here. And instead,
3
you didn't take
months.
stock. Instead, it's like, woohoo.
So was that
I'm free. I can
alcoholic
do whatever I
beverage
want
worth
to.
3 more
And you
months?
can't.
No.
All right.
This is what the court will
There's
do.
to be 90 sober meetings.
Court is going to
in 90
deny the
days.
motion. TAP evaluation, alternate amend conditions, and follow TAP recommendations, but we'll start with intensive outpatient treatment to include the
All right.
following.
You
There's
can
to
either
be
do
no
monthly
driving
UAs, or either you can
until
have a
further
drug
notice.
patch. Drug patch gives you a little bit more
Extend
freedom. They just put a patch on you,
3
and that
months.
patch will
So was
determine
that
whether or not
alcoholic
you
beverage worth 3 more months?
taking any illegal substances or substances at all. But the patch
There's to be
costs more.
90 sober meetings in 90
Go with the
days.
monkey.
All right.
There's to be random
Monthly
TAP
UAs.
evaluation. And follow TAP
Probation. Is there anything
recommendations,
else?
but we'll start
All right,
with
is there anything
intensive
else you need from the
outpatient
court to
treatment.
be successful?
All right. You
All
can
right,
either
we
do
can go off the
monthly
record. Here's the
UAs
thing.
or either you can have the drug
time
patch.
is coming up.
Drug
People
patch gives you a little bit
love
more
to
freedom.
celebrate Fiesta.
They just put a
and they
patch on you,
celebrate it
and that
sometimes
patch
by drinking
will,
a lot because every booth you
determine
pass,
whether or not
they have
you've
alcohol.
taken any
You are
illegal
not allowed to
substances
drink
or substances
alcohol while
at
you're on
all, but the
probation.
patch costs
If
more.
you don't like those rules, you need to write your
Go with the monkey.
legislature and say,
All
hey,
right.
could you change the
There's
rules
to
and
be
allow people to
random
drink alcohol when they're just chilling
monthly
at their home?
UAs.
Until that's done,
Probation, is there anything else?
those are the rules. You understand?
All right, is there anything else you need
All
from
right,
the
if you
court
need
to be
anything, let us know.
successful?
Good luck.
Judge Stephanie Boyd presided
All
over
right,
the
we can go off
sentencing
the
hearing
record.
of
Here's
Jesse
the
Lutenberger,
thing.
who entered a no
Fiesta
contest plea
time
to the
is
lesser
coming up.
included
People
offense of assault causing
love to
bodily injury, a
celebrate
Class
Fiesta,
A misdemeanor.
and they celebrate
The
it
hearing
sometimes
focused
by
on the
drinking a
court's
lot,
acceptance
because
of the
every
plea
booth you
agreement and the
pass,
appropriate
they have
conditions of
alcohol.
deferred adjudication.
You
According
are
to
not
the
allowed
court
to
record, the
drink
case arose
alcohol
from
while
an
you're on
incident at a
probation.
polling location
If
in
you don't
Bexar
like those
County,
rules,
Texas.
you need to write
Prosecutors
your
allege that
legislature and say,
Lutenberger
hey,
struck
could
an
you change
election
the rules
worker
and allow
after being
people to drink
instructed to
alcohol
remove
when they're
campaign
just
apparel
chilling
while
at their
still
home?
within the restricted voting area. The court
Until
reviewed
that's
the written
done,
stipulations,
those are the
police
rules. You
reports, and the
understand?
negotiated plea before
All right, if you need
proceeding
anything,
to
let us know. Good
sentencing.
luck.
During the hearing, Lutenberger told the court that he believed he acted in self-defense and described the encounter as a misunderstanding involving election procedures. Defense counsel also argued that there may have been confusion about when campaign materials were prohibited, while acknowledging that the applicable law had been violated. Judge Boyd explained that the court was required to rely on the signed judicial confession and stipulated evidence submitted as part of the plea. The court noted that the defendant had admitted to intentionally causing bodily injury and emphasized that election rules must be followed regardless of disagreement with those rules. The judge also addressed the importance of resolving disputes without resorting to physical confrontation. The court accepted the negotiated disposition and ordered 2 years of deferred adjudication. Additional supervision conditions included a $500 fine, 200 hours of community service, restitution, a hostility management course, regular reporting under community supervision, proof of employment, restrictions on employment involving home health care or minors, and no contact with the complainant.